Welcome to Not Guilty, Lawyers, Guns, and Money.
Welcome to Not Guilty, Lawyers, Guns, and Money with Edward D. Johnson III, founding attorney of Edward Johnson and Associates, P.C. Edward is a Chicago criminal defense attorney who regularly represents clients at some of the earliest and most critical stages of a case, including detention hearings, where a judge decides whether someone stays in custody or is released. I'm LeAnn Lyon, and today we are breaking down how detention hearings work and what's really at stake in that first appearance in court. Hello, Edward. Good to see you again.
Good to see you, LeAnn. Thanks for having me.
Edward, after someone is arrested, where does a detention hearing fit in, and how quickly does it happen?
Well, here, let me explain to you just kind of how we got to detention hearings in Illinois. And the governor passed the bill that required, eliminated cash bail. So you used to be able to post money, get out of jail. The money was a promise that you would show up to court, and they thought that that was affecting people that didn't have a lot of money, and they wanted to remove it. So Illinois started doing detention hearings now, and there's certain charges that fall within the detainable offenses. And once you get charged with one of those offenses, then they decide whether or not to release you or to have a detention hearing, which has three factors into deciding the basis for your release. And no money ever exchanges hands anymore. You might hear stories about, it would be $50,000 to get this person out of jail, or $1 million. Now it's just a determination by the judge at your first appearance in court, and they make this determination off three factors, and they decide whether or not you'll be released or if you're going to be held for the duration of your case. It's really new. It's fresh. It's only been a couple years. There's a lot of case law coming down on it, but you get arrested. Let's say you get caught with a firearm. You have a firearm on you. It could be possibly a detainable offense if you have a felony conviction in the past. There could be some issues, so they're gonna actually determine whether or not this case is detainable or not. If it's detainable, then you're going to move into something similar to a bond hearing, but it's going to be within the next 24 hours of you being booked by the police department.
Okay, so what I heard you say there is that the days of the bail bondsman isn't completely over. It just doesn't come into play this early in a case.
Oh, no. It's gone. There's no
It's
bail.
gone.
They got rid of bail bondsmen in Illinois, and then it was just the clerk that you would post the money to, because it was in Illinois, it got corrupt, believe it or not. And so they eliminated bail bondsmen, and now it was the clerk system. I still have clients sometimes that have warrants that still have old bonds up, from 2023 and beyond that, before this law passed. But now it's just, this is how they determine once you get arrested if you get released. So if you have a case where it's a minor traffic offense like a DUI, you won't actually have a detention hearing. You'll just be released, and you have to go to court. They'll give you a court date. They don't take your driver's license. They don't do anything to promise that you're there. There's just, if you don't show up to court, they'll suspend your license. But if it's a felony or domestic violence, something that has certain ramifications towards violence, then you're going to get into that detention hearing, and you're going to want an attorney there. If you can't get an attorney there in time and you're detained, we also do appeals of the detention. So once you hire us, if we're already a couple months down the road and you've been detained, or you're a couple weeks, what we'll do is get the transcript from the first hearing. We'll put a petition for relief in and have the judge where your case has been assigned. We'll have them make the determination again, review what the initial court, the detention court, decided, and try to get you released. And if the judge agrees with your detention, we'll appeal it to the appellate court based off of that petition. So we've been doing a lot of those. It sounds like a lot, because it is, but we think it's important that we send these up to the appellate court, because a lot of judges are making emotional decisions just on what they think might be dangerous. And we can go through those factors too in a little bit. I can kind of explain to you where we think some of the problems have been. determined by the judge and trying to fix those in the appellate court.
Well, that actually was my very next question is what is the judge actually deciding in that moment in that detention hearing?
It's deciding a three-prong test. So the first prong is whether or not there's evidence of guilt, whether or not they have enough in the first prong. Do they have enough evidence by clear and convincing evidence of that you are actually guilty of committing this offense? Now, it's not like reasonable doubt, like at a trial that you hear about. It's close, it's up there, it's a little higher than probable cause, but they're just looking for anything that can establish guilt. So if you have an officer's testimony that I pulled them over and they had a weapon and they're the only one in the car, then you could be detained on that, on the first prong. Then the second one is whether you're a flight risk or you're dangerous. And that's determined based off of a report by pretrial services that they'll interview you while you're in jail. They'll put together a rating on how dangerous and how much of a flight risk you are. The judge considers that. And then the third one is whether there's conditions that could be applied that would still make sure you come to court. And I'm trying to simplify it for the viewers so everyone can kind of see these are, not verbatim of what they say the law things are, but it just makes it easier for everybody to understand.
So, what is the prosecution trying to show in order to keep somebody in custody?
So they're going to show that you committed an offense that by clear and convincing evidence. The next one, they're going to show that you could be a danger or a flight risk. So they're going to look at whether or not you've shown up to court before, how many times you missed court, if you're a flight risk or if you're dangerous to a certain person. So if it is a domestic case, there could be a significant other that could be under threat and dangerous, and you could be, have a person that you've assaulted. There could be other things that make you a dangerous person. If it's like a certain gun that you have, or if you're not allowed to have guns and you get caught with more guns, it's kind of that situation. Weapons, fireworks, drugs, different types of things that they do in the second factor. And then the third is the state's attorney is trying to say that there's nothing you could do, like electronic monitoring or any condition that they can add that would make sure, like a curfew, that you would show up to court. And so you should be detained the whole time. And there's like that's really like our biggest factor that we focus on is the third prong, because there are a lot of different options now, like electronic monitoring, pretrial services, check-in, phone call, that they can keep track of our clients and why do they need to be in jail for this. They can be on electronic monitoring and still be able to travel, go to work, take their kids to school, do the important things like in everyday life while you're sorting this out. But you can see though, like how it works, especially in Cook County, is like on Saturday, they'll have 600 people probably arrested, and they'll have to go through all those different charges, and then they sort them out to where there's probably about 20 that are going to get detained, and those will put those in a separate room at 26th Street and go through them all and have these hearings. And it's really a dogfight with little evidence. Yeah, it turns into a big brawl, so to speak, because they're alleging all these things, and you've talked to your client, and you're just trying to get them released. And worst case scenario is, and it's in the law, is that like we can bring up detention every single court date after that too. So it's not like you're going to be in there forever. And there's a 90-day rule that allows you to, if they can't bring the case to trial in that time, they'll get you released if the burden's on the state there. But that's a nice little trapdoor to help people get released.
So, how much time do you realistically have to prepare before one of these hearings?
Not a lot. And I would say, it's, as soon as they get arrested from when you hire us, it's probably like 5 hours.
Oh, wow. The detention hearing can be 5 hours after an arrest.
Yeah, it can be, but usually you don't find out someone gets arrested, let's say Friday night. They're not allowed to make a phone call till like Saturday morning. Huh. And that's usually we'll get hired Saturday morning. I'll go down to 26th Street, get there about like 11, and I've already talked to them. I'll talk to the family. They'll tell me everything about your background, your employment, what you've been doing, if you own property, your ties to the community, the really important things that really humanize it to the court. And then we're trying to get all this information. Then I'll come and talk to you in the lockup, and then talk to the pretrial services regarding what they're raking, how their how your value is on their raking system towards the release, and then we have a hearing with the judge. You probably, it's give up 5 hours, I would say.
So, what factors tend to carry the most weight in the decision to, have somebody be released?
Yeah, the big factors, I think, mostly like the real good factors are your employment, what you've done, your criminal background is, they're always looking for that. If you don't have a background, or if you had like a FOID card, like a lot of people get arrested with a firearm carrying it, they have FOID card, not a CCL. So if you have that FOID card first, I know you're in good shape. They ran a background check on you. You passed that. They allow you to purchase firearms, but you don't have the additional licensing, or you're waiting for it. Sometimes people send it to Illinois State Police, hasn't came back yet. They're thinking they're good, which is not true, and they need to wait to get the licensing. But then you have something to work with the judge, kind of explain to them what's going on. Other factors, like if they're pulled over in a car, it's a rental car, or if it's somebody else's car, and they find a weapon where it is in the car, that tends to have a lot of weight. How many people are in it, but um, it really comes down to background and what the actual charges are. If it's something of violence, like they're trying to detain you, if you got in a fight, if you're using weapons, shooting at people, they're not going to release you unless you bring up good reasons why, and can show that you have a place to go, that they can bring you to court. And it's really important that you hire a lawyer right away and be ready to provide all that information. Or if you weren't and now you have the money, we can attack it later on in the case, try to get these people released. And that's where we've been really successful, is getting those petitions for relief and filing those appeals in appellate court and getting people released. It takes a little bit, but it's worth it. Some of these cases last 2 to 3 years. We try to get you out right away, even after they make that determination to detain you.
So, where do these hearings tend to turn? I mean, at what ends up making the biggest difference between release and detention?
It's kind of what I said. It really comes down to your background, what you're charged with. If it's a firearm, and let's say it's a ghost gun where it doesn't have a serial number on it, or you have the state's attorney, I think Miss Burke right now, she's really adamant about distinguishing weapons that have laser sights and that don't, for some reason, and extended clips. That's where they have their office's policy is, they're trying to detain people that have firearms with an extra mag, with a laser sight. I don't agree with it, but that has to be in Cook County one of the biggest factors in the detention, because they think that those guns were going to be used for something malicious, which I completely disagree and think that's wrong. But that's where I've seen a big divide.
Can you share an example of a detention hearing where you were able to flip the script and have the person released when maybe it was headed the other direction initially?
Yeah, one of my recent cases was, I had a client that went into a store, and there was a security officer there, and they had a bit of a discussion about something. I think everyone was having a bad day, and it kind of escalated, and my client wasn't allowed to actually get into the store. It was just a grocery store. Then he got back into his car and left, and that security guard called the police and said that my client had pointed a gun at them, which they didn't, and was detained. We got hired, went to preliminary hearing. It was indicted. We had a first appearance at 26th Street. I discussed detention on the first date, and then we brought up the fact that was in his car. The firearm that was found was registered to the owner of the car that was in the car. There were certain things and conditions that the judge was in agreement could allow his release as long as he followed those conditions, and that's how we ended up there.
Well, for somebody about to go through this or a family member watching it happen in live time, what should they expect walking into that courtroom? Earlier, you said it can be kind of a mess.
Yeah, it's a lot. What they can expect is that it's going to take all day. And if they are getting released and they're charged with something that isn't a detainable offense, they're gonna get released. They're gonna take all day though. If you go to that hearing and you're like, okay, he's gonna just walk right out the building in 20 minutes, not a chance. It's gonna be about 6 hours, 8 hours. Your loved one's gonna get a bus pass. They'll be able to make one call like 20 minutes before they're released, and then they're just dropped out at 26 in California and get on the bus, try to get home. So you got to try to get your timing right. If you just think I get there at 1 o'clock, okay, he's going to get released. Like, no, it's going to be 7, 8 p.m. Well, you should go do something else. Wait for the phone call, then come down there and pick him up.
So why does it take so long?
Well, that's something to ask the sheriff.
Yeah.
Yeah. So I mean, you can ask Dart about it. I think it's really a question for them. I would guess it has a lot to do with like the organizational procedures of the sheriff's department, and I think they also run background checks through that take forever, and they have to make sure that there's no outstanding warrants before they release you. They're trying to make sure you're the right person who you say you are, and that kind of takes a while. And then if there's a shift change, you're subject to that, and that usually falls in around 4 and 5. So then those same people then have to review the work, and then it's finally 7, 8 o'clock you're getting out. But yeah, it's very bureaucratic, believe it or not. Yeah.
So as we wrap up today's episode, is there anything that we've missed?
No, I just think it's important that people understand the process for how detention works. It's based off of what the charges are, what the actual charges, what you're being charged with, how that falls in the law, and whether you can look this up yourself and see, okay, someone's getting charged with a DUI. Is that a detainable offense in Illinois? If it is or it isn't, you'll know if they're getting released. There's no more cash bail. That's super important. I want everyone to realize that. So it's not a bond hearing anymore. They call it a detention hearing. And we're here to help everybody through this process, and to call our office, and we'll help them out.
Well, that's good news to hear. Thank you so much for everything you've shared today. And to our audience, thank you for listening to Not Guilty: Lawyers, Guns, and Money with Edward D. Johnson III of Edward Johnson and Associates, PC. If you or someone close to you is facing a detention hearing or has recently been arrested, visit edwardjohnsonlaw.com to learn how Edward and his team can step in early and fight for your release. Remember to like, leave a review, and subscribe to the show so you don't miss the next episode. Thank you, Edward.
Thank you, LeAnn.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.